5 seconds to go. Start. The Constitution Bench of this court, by its judgment dated 2nd September 2014, concluded that in all cases in which death sentence was awarded by the High Court, such matters be listed before a bench of 3 judges. Stop. The relevant observations in paragraph 39 were as under: para. Henceforth, in all cases in which death sentence has been awarded by the High Court in appeals pending before the Supreme Court, only a bench of 3 honorable judges will hear the same. Stop. This is for the reason that at least 3 judicially trained minds need to apply their minds at the final stage of the journey of a convict on death row, given the vagaries of the sentencing procedure outlined above. Stop. At present, we are not persuaded to have a minimum of 5 learned judges hear all death sentence cases. Stop. Further, we agree with the submission of Shri Luthra that a review is ordinarily to be heard only by the same bench which originally heard the criminal appeal. Stop. This is obviously for the reason that in order that a review succeeds, errors apparent on the record have to be found. Stop. It is axiomatic that the same learned judges alleged to have committed the error be called upon now to rectify such error. Stop. We, therefore, turn down Shri Venugopal's plea that 2 additional judges be added at the review stage in death sentence cases. Stop. Para. A question still arose, whether in matters where the review petitions had already stood rejected when the aforementioned decision was rendered by the Constitution Bench of this court, could there be reopening of the matter and the review petition be reheard? Sign of interrogation. A subsequent Constitution Bench in its order dated 19th January 2016 observed as under: para. In the circumstances, therefore, and especially in view of the fact that the petitioner is perhaps the only person that will suffer the denial of the right to an open court hearing, we are inclined to modify the judgment on review and direct that the petitioner shall also be entitled to seek reopening of the dismissal of the review petitions for an open court hearing within 1 month from today. Stop. We permit the petitioner to raise all such additional grounds in support of the said review petition as may be legally permissible to him. Stop. Para. In this backdrop, the instant review petitions are listed before us for rehearing. Stop. Para. At this stage, we may set out certain circumstances which were found to have been proved by the High Court and this court. Stop. In paragraph numbers 182 to 191 of the judgment, which is presently under review, it was observed as under: para. The High Court has held proved the following circumstances against the appellant: para. On the night of 22nd December 2000, there was an incident of firing inside Lal Killa when some intruders had managed to enter that area of Lal Killa where the unit of 7th Rajputana Rifles of the Indian Army was stationed. Stop. Para. In that incident of shooting, the intruders had fired indiscriminately from their AK-56 rifles, as a result of which 3 army jawans received firearm injuries and lost their lives. Stop.